Operations at ArchCity Defenders. I'm sorry you hear my puppy barking in the background. Eventually she will get herself together. But thank you all so much for attending. Again, my name is Inez. I'm the manager of community collaborations at ArchCity Defenders, and I'm very happy to introduce my colleague, Martin Hutchins. He is an attorney at ArchCity Defenders, and the expungement program is his baby. I'm so glad that we actually finally get to present what Martin has been working so very hard on, and we believe that it will be a great resource to the St. Louis area and surrounding areas. It really feeds into this idea of re-envisioning public safety that ArchCity Defenders has been working toward for a long time. When we say re-envision public safety, we mean to divest from the carceral system and invest in people so that people can live their whole full lives. That is how we make our cities safer. It's how we help our communities thrive, by doing things that ensure people have the best opportunities possible. And with the expungement program, what it allows us to do is help people get their records cleared, because having a criminal background keeps people from being able to access the full range of resources that they not only deserve, but are entitled to. Having something criminal on your background can keep you from getting a job. It can keep you from having access to safe, affordable housing. It really prevents you from being able to live your best life. So I am going to turn it over to my colleague Martin, and he's going to dig into it. If you have any questions, please feel free to utilize the chat, and we can answer questions as we go along. Again, thank you for being here. We're happy you're here. Now, Martin, let's get started.
Thank you very much for that, Inez, and I appreciate you starting me off with such positive energy. So as Inez said, my name is Martin Hutchins. I'm a staff attorney with ArchCity and also the Racial Justice Fellow. And I'm excited to introduce our expungement efforts at ArchCity. So as a primary piece of information, our goal today is just to provide the greater community with education and a bit of information about expungement in Missouri, to hopefully lead to the bigger goal of inspiring people to just start considering their own journey with expungement, if they started it or if they should start it. We have data from Missouri, the courts and the Department of Corrections, that just really shows that so few people in Missouri are really pursuing expungement. In 2018, nearly 1,200, and by nearly, I mean a bit under, so not over, but a bit under 1,200 people apply for expungement statewide. And of the nearly 1,200, only about 378 of those applications were from the greater St. Louis area. So as Inez mentioned, as we continue our work towards re-envisioning public safety, again, we really want to inspire people to start considering their own journey with expungement. So again, also as Inez stated, if at any point you have any questions, please drop them in and we will get to them at some point throughout this presentation. So generally, you hear so many different meanings applied to the word expunge and expungement. So just as a general matter, the word expunge simply means to destroy, totally erase. Now, as it relates, the word expunge relates to the legal process that we're going to be covering today. That definition is going to vary from state to state. And so as it relates to Missouri, Expunge, unfortunately, doesn't mean that the record is totally erased or destroyed. In Missouri, expunge means that the record is sealed. And so when we say sealed, this means the court record will become confidential and will be limited to a few specific parties and a few specific situations that will allow the court to reveal those records that were expunged. So again, in Missouri, when a person successfully is granted expungement, their record is only sealed. It's not totally destroyed. So as stated, those records still exist and are still accessible in certain situations or for certain parties. For example, pursuing certain jobs or going through the court process for offenses that may occur later in time. Those are all examples of situations in which those sealed records will be accessed. And further, in order of expungement, which once you go through the expungement process, the judge issues an order, which we'll go into more detail about later. But the judge issues an order of expungement, and that's what allows the records to become sealed. However, that order won't have an impact on any public existence of these records. So for instance, if someone shared your mugshot on social media, once you're granted expungement, that is very likely that mugshot is still going to be on social media. And if it's no longer on there, it's not a result of the expungement. That's just something else in the universe that removed that mugshot from social media. So again, in Missouri, getting your record expunged is just only going to make the court records sealed and confidential. So here in Missouri, Statute 610.140, which statute is just another word for law. This is the primary law for expungement, and this will be the focus of today's presentation. And in 2018, this law underwent major changes. And from that point, 2018 is still undergoing some pretty remarkable changes. So in 2018, with the major changes, so many more offenses became eligible, and the time periods for eligibility shortened. So once upon a time, an individual had to wait at least 10 years to pursue expungement for a felony. That time is now reduced to 7. So still a pretty lengthy period, but a bit of improvement. So again, as I just mentioned, the expungement law went through major changes in 2018. But since that time, a few more rounds of changes to the law has occurred. For instance, once upon a time with the current law, stealing offenses were ineligible, meaning if you were a person with a conviction for stealing on your record, that record just was totally ineligible for expungement. However, some of the recent amendments to that law remove stealing from the offenses that are ineligible. So as time goes on and more bills are passed, that's more opportunity for this law to become even better and to assist more people that may have some of those charges that are right now ineligible. As I mentioned earlier, the courts of Missouri typically publish a judicial report once a year. And this judicial report is it's a source. I want to backtrack the great part, but it's one source to get a view of the expungement activity in Missouri. So this lengthy report can give an indication of how many people are actually pursuing expungement, similar to the 1,200 figure that I mentioned earlier, showing how many people statewide pursued expungement again in 2018. And another reason to bring focus to expungement right now, as Inez mentioned, a criminal record just has such a great impact on an individual's life. The opportunity to pursue various careers or to have certain licenses like a barber's license. Those are all things in Missouri that can have a big impact from a criminal record. But now, during the time of this unique time we're in, because of this pandemic, we are constantly having conversations about going back into society and reopening society post-COVID-19. And that really makes expungement a really ripe issue right now, because as we are relaunching society, we must consider the barriers that people with criminal records are going to face. They're already facing them. And so the barriers that we all are facing and readjusting and going back into the world post-COVID-19, those with criminal records are going to be even further hindered and face even more barriers. So here, this is about a 5-point summary of the requirements of expungement. And this will be the bulk of the focus of today's presentation. So we would generally just cover what are the requirements for expungement so that I can assist whoever's out there watching now or later to begin that process of considering, am I myself eligible for expungement? Is this something that I should begin looking at for myself? Or perhaps you know someone that could benefit from expungement, or you can be a volunteer or an employee of an organization that further works with people that may benefit from expungement. So I'm going to go and unpack these 5 requirements. And finally, I will discuss the results following expungement and issues that people generally face. So the first requirement is the offense eligible for expungement. And so this requirement really focuses on the offense itself, meaning the offense that you were either convicted or arrested for. And so again, Missouri has a few different laws for expungement. However, 610.140 is the primary law and is Missouri's best expungement law. And again, not to give too much credit to the word best in that sentence, there's still a lot of room for improvement. But with this requirement, we're looking at the actual offense that got the person whatever record that they may have. So here, this is just going to consider, is this an offense that has either been expressly mentioned in the expungement law as ineligible, or does it fit into one of several broader categories that makes the offense itself ineligible? So I'm going to break this, the eligibility of the offense into 2 categories. And the first is going to be those offenses that are specifically listed as being ineligible. And so the laws, again, 610.140, which I will just keep referring to as the law or the expungement law, it lists about 85 statute numbers that shows laws that are, again, flat out ineligible for expungement. So here on this chart, there are about 10 of those offenses from the overall law, but there are about 85 offenses in total listed as being offenses that are just ineligible. So that means if you were either arrested or convicted for perjury, for example, as of right now, you are ineligible. So a few of those examples include arson in the second degree, and first degree arson is also included. Forgery, identity theft, mortgage fraud, perjury, possession of firearm for certain persons, robbery in the second degree, sexual misconduct in the first degree, and a violation of a protection order. And again, there's nearly 85 offenses that are totally ineligible. And as the presentation goes on, I will show you all a link that allows you to view the full expungement law for those that may want to go out and actually view the entire law, or even just review the section of offenses that are, again, ineligible. And so, as I mentioned earlier, there have been changes to the law even since the major change in 2018. And again, once upon a time, stealing was a part of this list of offenses that were ineligible. So one thing to optimistically look forward to is this list becoming smaller and smaller. And that's, again, me being very optimistic and hoping that our elected officials will continue to remove offenses from the exclusion list so that more people can pursue expungement. Now, other than the offenses that are specifically listed as being ineligible, there are a few broader categories, and there may be some overlap in these two. For example, the previous slide mentioned robbery, and robbery is also considered a dangerous felony. But again, those statutes were just explicitly listed in the expungement law as being ineligible. And so for those that were not included in that list, again, if they fit into any of these 10 broader categories, then the offense itself is, again, ineligible. So one, anything that's a class A felony is ineligible. Any dangerous felony, which generally will include arson, rape, sodomy, kidnapping, anything involving a special victim assault, crimes against children, habitual intoxication, boating offenses, and attempts to any of those crimes. So, example, attempted kidnapping, that will also be ineligible. So the offense itself, or even a conviction for the attempted commission of that offense. Number 3, offenses requiring registration as a sex offender. Felony where death is an element, for example, murder, first-degree murder, or manslaughter. These are going to be offenses that, again, are ineligible because they fit into this broader category of felonies where death is an element. And so here, when we say where death is an element, that means that this is something when you either went through trial or accepted a plea deal, this would have been a requirement that the state proves to give you or to convict the person. So again, any offense that death is a part of will be flat out ineligible. Number 5, any felony offense of assault, domestic assault, and that includes at the misdemeanor level or the felony level, and felony kidnapping. Now, this section is being pulled directly from the statute. And as I show you the link that allows you to actually view 610.140, you can go back and again view those specifically listed statutes and these various categories that I'm going through. Number 6, and this is the section that I broke down first as the specifically listed offenses. So I won't go over that at this moment because we already covered it. Number 7, any offense eligible for expungement under any other law won't be eligible for expungement under this law. So that includes offenses relating to alcohol-related driving offenses. Those laws have a way for expungement within themselves. So therefore, you can't pursue expungement under this law. Now, in going through all of this information, again, our goal is just to provide education and to raise awareness to the community itself. And I say my following statement with full recognition of how much privilege is in this statement, but it's so very important to pursue legal assistance in going through this process. As we have already covered, there's so many parts to have to cover and so many issues that can be faced during this process. And we'll unpack that a bit more. But in mentioning that, making the decision on the best law to pursue expungement for is totally something legal counsel will assist with. Number 8, some intoxication-related traffic, boating, or aircraft offenses. Again, those are flat out ineligible for expungement under this law. Number 9, ordinance violations that are the substantial equivalent of listed non-expungable offenses. So generally, when you hear ordinance violation, you can think of citations that you may receive in one of the several municipalities that we have here in St. Louis. Those are going to be municipal violations, ordinance violations, pardon me. And so the substantial equivalent would be any ordinance that's pretty comparable to a Missouri state law. For example, most all of our municipalities has an ordinance relating to trespassing and stealing. And so fortunately, both of those offenses are eligible, but before stealing became eligible, again, once upon a time, it was an ineligible offense. And so a conviction at the municipal level for stealing would also be ineligible. And so again, this is another opportunity for legal counsel to help you understand what ordinance violations are going to be substantially equivalent to Missouri state law. But later in the presentation, I will also show you a site that you can visit to pull various laws. And again, I say that in fully recognizing our laws generally just aren't the easiest to read and navigate. But with recognizing that, I still want to show you a resource to actually pull the law. Number 10, any violation of law regulating operation of motor vehicles by a person who is required to have a CDL anywhere. So if you are a person that has a CDL or you are required to have a CDL license, you have an offense relating to motor vehicles, again, that offense will be ineligible. And number 11 relates to carrying concealed offenses. And so again, that segment just really covered exploring if the offense itself is eligible. So there are a few more requirements for expungement that we are going to cover. And again, the requirement that we just covered only focuses on the offense that got the person the criminal record that they are looking to overcome, whether it's a record of just an arrest that didn't result in conviction or even charges being brought, or a record relating to a full conviction. So the next requirement that we're going to cover relates to time. So there are two requirements that relates to time, as the slide indicates. And so before going over those two specific requirements, I'm going to quickly talk about calculating that time. So the courts calculate this time by counting backwards. And that time is from the date in which the expungement petition is filed, again, counting backwards. So if you are a person that are just thinking about if expungement is right for you, it would be a great idea to just look at the current date and count backwards. And that's just to give you a starting point, because of course you're not going to submit your petition on the very first day that you start making those considerations. So as time goes on, that time period is going to change. But just to start making those early considerations and starting to think about that process, a good starting point would be using the current day and counting backwards. And so the time is going to vary depending on the level of offense. So first, for felony offenses, and this is going to be felony convictions or arrests relating to felony offenses, the waiting period is 7 years. So today, if I wanted to consider expungement, I would take today's date, October 20th, 2020, and count backwards 7 years. So that puts me around October 20th, 2013. And during that count back period, there are a few things that has to happen. So first, the disposition has to be complete. And disposition is just another way of saying sentence. So for example, if I have a conviction for property damage and I was sentenced to probation and to pay $500, my disposition is complete once my probation period is successfully over, meaning I was successfully discharged by the probation officer, and my fine is either paid in full or otherwise indicated as being satisfied by the court. So again, during that countback period, my disposition has had to be completed for that 7-year period. And next, also relating to that time period of counting backwards, I have to show that I have been essentially crime-free during that period. So again, if I'm looking to expunge a record relating to a felony, from today's date, October 20th, 2020, all the way back to October of 2013, I have to have been crime-free for that period. And so the law indicates there can be no new convictions or finding of guilt by the court. So during that 7-year period, no findings of guilt by a jury, no no guilty pleas entered, and any other situation in which a finding of guilt can be entered for a person. And if so, then the period in which a person can pursue expungement is just going to increase. So during my 7-year period from October 2013 to October 2020, if I was in fact found guilty of another crime in 2015, then I'm going to have to wait 2 more years because I am not in compliance with that 7-year crime-free period in order to get my felony expunged. Now for misdemeanors, that time period is a bit shorter. It's 3 years. So that means 3 years back, my sentence, all the obligations ordered by the court as part of my sentence has to be fulfilled. And again, I must have been crime-free, meaning no findings of guilt for that 3-year period. Now, a bit more about this crime-free period. Generally, this does not include minor traffic violations, but traffic violations regarding driving while revoked or suspended or without insurance are not included in that exception. So if I have recently pled guilty to a violation of driving while suspended, that will prevent me from being eligible for expungement, which means I need to wait a little longer. So one benefit to the count back period is if a person is deemed ineligible because they are not in compliance during that 7 or 3 year period, they can just allow a little more time to progress, and they will eventually become eligible as far as the time period. So the next requirement really covers a person's current standing with the court system and not having any other pending charges or tickets out there, which more often than not, people can have tickets that they have forgotten about, tickets that have taken quite some time to be processed by the prosecutors or officers. And you would be surprised to know how many people unwittingly have warrants, again, for matters that are really old or matters that they believed were once wrapped up, which isn't very hard to do, especially living in a metropolitan area with 40 plus municipalities, some of which you can encounter going down one street. It's easy to understand how people can have multiple tickets out there and lose track of them. So as far as the requirement of relating to unsatisfied obligations and pending charges, one, have you satisfied all obligations relating to the offense? And so here, when we say the offense, this means the offense that you are aiming to expunge. So again, going back to my property damage example, have I satisfied all the obligations relating to my conviction of property damage? So this has some more, some overlap with one of the earlier requirements that we mentioned. But again, this is only relating to the offense itself that you are aiming to expunge. So again, all of those obligations ordered by the court must be satisfied before you can be deemed eligible for expungement of that offense. Next, do you have any pending charges? And in a few slides, again, we're going to go through a few sites that allows you to start looking at your own record, like CaseNet. And I mention those because that's a great way to identify if there are any pending charges. So again, any pending charges will hinder you from getting expunged. So the next requirement was the court's discretion determined that overall you deserve to be granted expungement. This requirement really allows the judge and the court to use their own judgment to determine if the person overall deserves expungement. So here, this is a subjective determination being made by the judge using their own judgment. So the earlier requirements that we covered are all objective, meaning you either do or don't have pending charges. Your offense itself either is or is not eligible. But this requirement, again, is going to allow the judge to use their own judgment in determining the expungement applicant's overall person to determine if they think they deserve expungement. So the first requirement here is, does your habits and conduct demonstrate that you are not a threat to the public safety of the state? And next, that the expungement is consistent with the public welfare of interest and the interests of justice warrant expungement, pardon me. So again, these requirements are going to be more so matters that the judge really has to inject a lot of their own discretion and judgment in making. So some information that can really be helpful here is information showing the person pursuing expungement, if they're employed, that can really be helpful in making the judge's determination weigh in their favor. Any information about furthering their own education, their involvement with their family life, community involvement, etc. These are just examples of information that can be provided by the person pursuing expungement so that the judge's discretion will go in their favor. So I'm going to take a few moments just to pause to see if I have any questions that have been presented.
There are a couple of questions, Martin. I don't know if you've gotten to this point yet. We have, I think, 5 questions. Do you want me to go through them now?
Let's see. Okay, yes. Thank you for bringing this to my attention, Inez.
Okay.
Okay, so one question that's been posed, and just for the sake of anonymity, I won't say the names of who asked what question. This question is, I have something on my record from 2000, and when inquiring about getting it expunged, I was told that I couldn't. Is there certain things that you can only get expunged off your record? Good question. So some of the information that we just covered goes towards this question. And so there are, again, a list of specific offenses that just cannot be expunged. Other than those specifically listed offenses, there are a few broader categories like dangerous offenses, offenses that require registration on the sex offender registry. Those are offenses that just can't be expunged. This question also mentioned that the record relates to the year 2000. And so it's also important just to know the various dates relating to your record. But this question presented is a perfect example of a person that should reach out to legal counsel, and even if it's just at a level of getting a consultation to see if the attorney will work with you so that you can get a better understanding of if expungement is something that you can pursue. So as we're going through this information, it's very easy to get discouraged by all the requirements that you have to meet and all the information that you need to discover to determine your own eligibility. But with that, I say all that to encourage not to be discouraged. And as you're thinking about this process as it relates to yourself, reach out and try to find legal counsel that can, at the very least, help you make an early determination if this is something that you can begin to pursue. So next question I have is, are stealing charges ineligible for expungement? So as of right now, stealing can be expunged. When the law was just changed in 2018, it was once an offense that was totally ineligible. However, back in 2019, I believe around August 2019, the law was amended and stealing is now eligible. So the short answer, yes, stealing offenses can be expunged. Of course, pending all the other requirements being met, but stealing itself is eligible. Okay, and the final question I have now before I progress with the presentation: can the court, in its discretion, expunge records that would otherwise be ineligible for expungement? Thank you for asking that question. As of right now, if the law indicates that an offense is ineligible, either because it fits into those broad categories or it is specifically listed, then no, the court in its discretion cannot grant expungement. But again, I want to fall back on, if you are an individual making the consideration to pursue expungement, even if you are of the belief that you are ineligible, I would still press you to pursue legal counsel. One, legal counsel can confirm whether you are eligible or ineligible for expungement. But there are a few other legal mechanisms in which such ineligible offenses can be attacked for the integrity of the conviction itself. So again, please don't be discouraged by that. But the short answer to your question, no, the court in its discretion cannot grant expungement where the law says that the offense itself is ineligible. Okay, next. So now I'm going to cover lifetime limits. And these are just limits that the statute has created for how many expungements a person can be granted. So in short, as of right now, a person may only be granted an expungement for 2 misdemeanors or ordinance violations that have an authorized term of imprisonment and only 1 felony. There is no limit to how many infractions may be expunged. So to just unpack the misdemeanor component, if there is an authorized term of imprisonment, there is a limit of 2 expungements that may be granted. Now, the majority of misdemeanors have authorized terms of imprisonment. As a general matter, Class E misdemeanors are going to generally be those misdemeanors that do not have an authorized term of imprisonment. Otherwise, most misdemeanors have an authorized term of imprisonment. So again, that max amount as of right now is 2 misdemeanors. Again, 1 felony. And so again, it's important to remember that the law in this instance doesn't make a difference between a conviction or arrest. So if a person has a record relating to an arrest for a felony that was later never filed, you can pursue expungement for that, but they're still going to be subjected to this limitation. And again, there is no limit to how many infractions may be expunged. A quick example of infractions can be those minor traffic violations. which could be helpful for a person pursuing a job that requires a lot of driving. And so here I use the phrase full expungement. For purposes here, full expungement allows a person to say they have no criminal record. However, more often than not, people have multiple offenses that can be expunged. So deciding whether to seek expungement now and which offenses to expunge may be difficult. And that may be difficult, again, considering these limitations. But to just even further this, it's so very rare to encounter an individual that only has one felony. The way the American legal system is, we are all too familiar with the practice of charge stacking and all the other various systemic issues that comes into charging and ultimate conviction rates. And so I say that to say, again, it's so very rare to come across a person with only one felony offense or only one offense on their record. And so ideally, a person being able to be granted full expungement is best because they position you to not have to report felon status anymore. However, there are still benefits to pursuing expungement for one felony despite having multiple. And again, that's going to be a case-by-case basis that working with legal counsel can absolutely help determine the best route for expungement and which offenses may help you reach the goal that you are aiming to reach in your pursuit of expungement. And so the expungement law gives it gives two exceptions. One exception with two ways to reach it. So if you were convicted of 3 felonies, but all 3 felonies was part of one case and one indictment, then there's an exception that says because all of your convictions were all on the same indictment, those 3 felonies can be expunged. And of course, that's with the consideration that all the other requirements can be met, meaning none of those 3 felonies on that one indictment is an ineligible offense like murder. So if there's one indictment with 3 eligible felonies, then that person can be granted expungement for all 3 of those felonies. And so of the 2 ways to reach the exception, that's by far the easiest. The second exception is when the multiple offenses were all committed as part of the same course of criminal conduct. And again, this is another example of why using and relying on legal counsel is going to be so important. And again, I say that with the full recognition of the hardship that follows obtaining legal counsel, even legal counsel at no charge. Those options have such large caseloads, so it's not always easy to get free legal counsel. And paying for legal counsel can be really expensive. So again, I recognize the privilege in that statement. But again, legal counsel is going to be the best in determining if that exception applies, and the best way to show the application of that exception to help you get as many offenses expunged off your record as possible. Okay, so I think this is another good spot to pause to see if I have any more questions.
Martin, did you get the questions that were in the chat?
I believe so. I believe those are the questions that I just answered.
Okay, just making sure.
Thank you, Inez. So I'm going to stop my screen share for just 1 second so I can make sure I have not missed any questions. Okay, I'm sorry, Inez. I just accidentally told the field. I did not address these questions in this chat. Please pardon me. Okay, so one question that I overlooked is, can a person with several felonies and misdemeanors have their record expunged? So the slide that we just covered really really provides the information for this question here. So several felonies, the only way several felonies can be expunged, again, would be if those several felonies are either on one indictment or one information, which the indictment is the charging document provided by the prosecutor. If there are several felonies on one indictment, then that person has the potential to be granted expungement for all of those felonies. And that's pending that all of those individual felonies are actually eligible, meaning no murder, no felonies that require registry as a sex offender, et cetera. And the same with misdemeanors. So with misdemeanors, there's a limit of 2 where there's an authorized term of imprisonment, which are going to be the vast majority of misdemeanors. The exception to that will be a few of the Class E misdemeanors. So outside of those limitations, you will need an exception to bypass those limitations. And so I'm going to skip over a couple of questions because another question kind of piggybacks off of that question. And this question just asked me to go over the second exception again. And so the second exception is if a person was charged for multiple offenses that all were a part of the same course of criminal conduct. So an example of this here is a case from about 2 or 3 years ago, which this person was not granted the exception. And that's a discussion for another day. But this person was pursuing expungement for several convictions of writing bad checks. And this person had an instance of writing a bad check in a store in Bell Fountain. And I'm paraphrasing and changing the story a bit. But this person had an offense of writing a bad check in Bell Fountain, and then 10 days later wrote another bad check in Moline, and then 5 days later wrote another bad check in Pine Lawn. And so this person tried to use the exception, and they were not granted expungement of all of their offenses. And one of the primary reasons the court did not grant this exception was just it was such a large, according to the court, too many days in between the offenses of writing bad checks. So if this person would have wrote a bad check on Monday, and then another bad check the following day in Moline, and then another bad check the following day in Pine Lawn, then that would be an example of the same course of criminal conduct, because this person has gone on a spree of writing bad checks. And so that's more likely to be considered the same course of criminal conduct. And so that's going to be an example, and this exception really requires a lot of litigation and a lot of argument building, which is why utilizing an attorney is so very important. Thank you for asking that. My next question is, if the offenses are eligible for expungement, is there a cost, and can more than one be expunged? So this is a 2-part question. So again, as we just covered, yes, more than one can be expunged if an exception fits, or if it's just something that doesn't reach the level of reaching those limits. So if I have 1 felony and 1 misdemeanor that I need to get expunged, that's 2 expungements I can pursue, and there's no need to even use the exception there. As far as cost, I'm gonna pause that because we're getting there. So you're beating me a little bit. Next, my next question is, does it matter if the charge was SIS or SES? That's an excellent question. And for those that may not be familiar, SIS is a suspended imposition of sentence, which means that the court allowed a person to undergo probation. And if their probation is successfully completed, then that person's offense is sealed. So as a quick matter, which we won't unpack too much in this presentation, you can pursue expungement of an SIS charge. However, an SIS already seals your record, so it won't be more sealed by pursuing expungement. But there could be reasons to pursue expungement of an SIS. For example, if a person is trying to have a right restored that they lost because of their SIS conviction, then expungement can be helpful there. And SES is suspended execution of a sentence, which means that, and I don't think I pointed this out with the SIS, but again, with the SIS, the matter is confidential, so the person's record isn't blemished with that offense. With the SES, there is a conviction entered on the record, but the actual time sentenced by the court is withheld, and the person is not confined if probation is successfully completed.
Martin, can I add something there?
Yes, please.
I had an SIS probation, and although it was a suspended imposition of sentence, it still showed up on my criminal background check. So just wanted to throw that in there.
Yes. So, and which Inez leads me to an issue that we are going to talk about a little later. But there are so many issues with just getting our records out there and making sure some records aren't still showing up for people when they shouldn't be. So for example, which I can't, of course, confirm that this is Inez's situation, but I have had experience in which a person has had a background check show information relating to an offense that is actually sealed by the court, but this background check found information from previous background checks that the person went through. So again, remember, expungement only relates to the sealing of the court records. Expungement would not cover any information provided by private parties, meaning individual people or private companies. So if a private company once upon a time saw a record of a charge that you now have expunged, it's a possibility, unfortunately, that their record can still show, which is just a flaw with the expungement system. Thank you for that segue, Inez. That was very helpful. All right, so I'm going to resume the presentation. All right, so now the results of expungement. And so by the results of expungement, I mean what happens after a person is granted expungement. So the court states that the goal of expungement is to restore the granted expungement to the status that they for the arrest, plea, or conviction occurred relating to the offense that was just expunged. One of the biggest results of expungement, generally everyday people more readily recognize, is the ability to deny having a criminal record. So when doing a job application, once a person is granted expungement, they can answer no to any inquiries about criminal records without without the threat of perjury or any other court action that may follow a person lying under oath. So once you're granted expungement, generally that allows the person to answer no to any questions relating to criminal activity. And there are a few exceptions there which we will cover. So once granted expungement, still must disclose that expunged offense to any court when asked or upon being charged with any subsequent offense, violation, or infraction. So again, if the court asks about any records, then the person is required to reveal information about the expunged offense. And as the next bullet indicates, expunged offenses can also be considered when the court is making sentencing determinations and when the prosecutor are making recommendations for sentencing for offenses that may be committed later on in time. Finally, the person that has been granted expungement must disclose when necessary to complete an application for certain licenses like nursing licenses. You have to disclose information about your offenses, even those that have been granted expungement, certain permits and certain types of employment. So again, as I stated earlier, there are a few situations and a few parties like the prosecutors that still have access to these court records relating to offenses that have been expunged, which is why it's so very important to recognize in Missouri, expungement does not mean that the record is wiped clean and erased. It's just sealed. And so a few examples of employment that requires disclosure of expunged records include any jobs involving gaming, like the casino, any state-operated lottery, any emergency service provider, federally insured banks, saving institutions, credit unions, and entities engaged in the business of insurance. Those are just a few examples of types of employment that require disclosure of expunged offenses. And so a few of the common issues that people experience in going through the expungement process. Firstly, the difficulty with gathering and providing correct and complete information. So when submitting the petition for expungement, and by petition, that's just the application that will be submitted to the court for expungement. So as a quick note, the expungement law actually requires each court to provide a pro se form for expungement. And so this means a form for people to represent themselves to pursue expungement. And the courts do indeed provide it. However, as I have been stating throughout this entire presentation, I really press individuals to pursue legal counsel when going through this process, because laws are just generally very, very dense and very confusing. Even for people that practice law, lawyers spend hours looking over laws and breaking them down to understand what they mean. So again, there's just so much hardship in reviewing the law and trying to meet all the requirements, which is why it's so very important to use an attorney when absolutely possible. So yes, a pro se form does exist I'm totally against that pro se form. And we'll discuss that a little more later. But in providing that petition, the application for expungement, each offense that the person wants to have expunged has to be listed. And so a problem there is, as I mentioned earlier, people often forget charges that they may have pled to 10 to 15 years ago. And so, of course, you can't list an offense that you want to have expunged if you don't recall it. However, it could be an offense that may be more important to have expunged to help that person achieve whatever goal they're trying to reach with their expungement, whether that's getting a better job or going back to or pursuing school and applying for financial aid. So again, the inability to really recall all the offenses is a problem with gathering that information. The approximate date charged for each offense. Again, this is information that the petition is going to require, but it's more common for people to forget exact dates than encountering people that actually remember exact dates. In fact, I can't recall any time in which a person was able to give me an exact date of their arrest, conviction, or any dates relating to their court case. People have very busy lives and so much going on and so many other things to remember. So an exact date is a little far-fetched to expect to remember. The name of the county or municipality for each offense. Again, with being in an area that has so many municipalities, some of which can all be encountered driving 10 minutes down one certain road, one certain rock road, it's so easy to forget not only the ticket that I may have gotten, but who issued this ticket. But again, listing these municipalities is information that's required for the expungement petition. The case number. Again, it's not easy for people to recall this information. In a perfect world, people would maintain those documents. However, that's again a bit of a far-fetched expectation, just considering in the grand scheme how much people are dealing with in everyday life. Now, in our review, that this can be one resource to try to identify case numbers, but there are so many flaws even with that system. And finally, the petition must list certain parties as defendants. And so in actually filing the application for expungement, for example, going to St. Louis County, the application would list the county prosecutor, so that's the Office of Wesley Bell, the county police, the criminal record repository, and the highway patrol. Now, as the location, the jurisdiction changes, which is going to change in according to where that person was either arrested or convicted. So if I'm looking to expunge an offense that I was convicted for in St. Louis City, then I need to list the circuit attorney office and the city, the St. Louis Metropolitan Police Department on my petition. It's going to change if I'm dealing with a record in St. Charles. It's going to change if I'm dealing with a record in Kansas City. And this piece of information is especially crucial because if a petition fails to list a required party, then that order won't have any power over them. And so again, the order at the end of this process, and if a person is granted expungement, the judge gives a court order that says this person's record is expunged, seal their records. And so in listing those 4 people, the court is telling those 4 parties to seal the records so that people in the public can't access them. So if I submit a petition to expunge my record in the city of St. Louis, but I don't include the police department, then the police department can still maintain that record, which will in turn have an opportunity for that background check I'm going to go through for a job I'm looking after to find that record, because St. Louis police still has that record open because they weren't listed. So again, this is just another reason why utilizing legal counsel is so crucial. Another issue, as we mentioned earlier, the expungement law has went through many changes, and I am going to project it that it's going to go through a lot more changes. And so with that consideration, potentially waiting to see if efforts to amend the statute and make it more favorable to expungement seekers might be a better approach. So again, earlier I mentioned in 2018, stealing was not eligible for expungement. However, today it is. And so as more and more offenses become eligible, it may be a need for people to wait. Again, if it's a person that has multiple felonies on their record, and unfortunately, the law puts them in a position to pick and choose which felony they want to have expunged. So that could be a reason to wait to pursue expungement, because again, there are lifetime limits. You can only have one felony expunged. So if I get a felony expunged today because my other felonies aren't eligible, but then 2 years from now, those felonies become eligible, I have already gotten my one felony expungement. So again, this is another plug for using legal counsel where possible in making your expungement decisions, because that attorney can help with those decisions and those various legal strategies of the best way to pursue expungement to fit the goals that you're aiming for. So a few more issues. In the first bullet, I think I appropriately placed on the issue slide because it relates to money. And this is an issue because, of course, as a part of the American legal system, we know that people of lower socioeconomic status are more often represented in the American legal system. And even further, people of lower socioeconomic status of color are especially more disproportionately represented. And so with that being said, there are a few fees associated with expungement. So there is a surcharge fee of $250 for expungement. In addition to that, there are basic civil filing fees, and those fees are going to vary from jurisdiction to jurisdiction. Now, this link right here will take us to a form referred to the application to proceed as a poor person, which is just a form that can be submitted to the court, asking the court to waive certain fees because a person doesn't make very much money. And so it's important to know that there is not a fixed standard for determining indigency. And indigency is just the way the court terms proceeding as a poor person. So there isn't a fixed standard. But again, this form is one way to address some of the monetary needs required with expungement. Unfortunately, there are so many more fees affiliated with expungement that court order won't have an impact on. For example, after going through the various free options to review your record, obtaining a background check from the Highway Patrol is a step that should absolutely be taken to make sure the information of your own record matches information that Missouri has. And that background check costs approximately $28, which $28 for a single parent family with multiple kids can be a lot, especially during this time of COVID-19. And this final bullet really captures why I'm pressing utilizing an attorney for this expungement process. If a petition is filed and the court determines that person is not eligible, that person cannot pursue expungement for that offense for another year. So that means that's another year of that person dealing with the impact that their criminal record continues to have on them, despite the fact that it shouldn't continue to have that impact. One of the issues that we are just becoming more and more aware of is just the grave impact that criminal records have on people well beyond completion of sentences. So again, filing a petition that is deemed to be ineligible means that person has to wait another year. So in utilizing an attorney, I think that's one of the best ways to try to avoid the year penalty. All right, so I'm going to take my final pause to review questions. We have about 7 more minutes in our presentation. Time really flew. Okay, no more questions. Inez, am I missing any questions?
I don't think so. I think we got them all. Yeah, I think we got everybody. If you do have any closing thoughts or last minute questions, please feel free to put them in the Q&A box, or you can put them in the chat. We'd be happy to answer them with the last few minutes that we have. We will be doing this again tomorrow evening at 6 o'clock. So if you know someone who could benefit from this information and they didn't have an opportunity to join us today, please ask them to join us tomorrow. And we're going to continue to do these educational webinars around expungement. And then hopefully by the end of the year, Martin, we will be officially launching to begin to collect information from people who may or may not need assistance. So please spread the word. Go ahead, Martin.
Yes, and as Inez says, we are making effort to be more involved with the expungement work at our city. But as of now, we're going to press people to keep an eye out on any announcement from our city. And the best way to get the information would be to visit our website and sign up for our mailing list, which I will show that link in one moment. And so if there aren't any other questions, I will end by
one.
So after this one question, I'll show a few resources that can be helpful.
Do you have any recommendations for affordable legal aid for individuals to pursue expungement?
Yes, great question. I'm going to lead this by saying I wish I had a longer list to offer as of right now, and I'm going to limit this to the greater St. Louis area. I would encourage people, and this encouragement is not an indication that these organizations will absolutely take you on, but nothing beats a fail like a try. So I will press you to apply. But Legal Services of Eastern Missouri is a great legal aid organization, and of course, ArchCity Defenders. So again, as I just mentioned, we as of now aren't doing expungement specific application intake. However, I will press you to do our general application just in the pursuit of general of counsel for legal needs that you may have, including expungement. Okay. Okay, so finally, a few of those resources that I mentioned, and these resources are just aimed to help help you all start your own considerations for expungement for yourself individually. And again, I'm pointing to these resources for your own help. So one option, these first 4 links are going to be options that people can start to search for records relating to their own criminal offenses. CaseNet, and I also say this, and again, fully recognizing that everyone doesn't have computer or internet access, and navigating CaseNet just isn't the easiest. So with all that being said, here's the difficult site that I just mentioned that you can try to take a look for your own record. And this is going to show things primarily at the state level, although more and more municipalities in the St. Louis area are starting to include information on CaseNet. So clicking here on the home button, you can do a litigant name search and search your own name. Another option would be municourt.net. And this just shows records relating to the municipal court. The next 2 options are specific to their jurisdiction. And this is for St. Peter's. And this is just their own traffic criminal case search. So if you maybe have an idea that once upon a time you got a few tickets or had an incident there, I would press you to just type your name there and see if anything comes up. And the same sort of system is available for St. Louis County. And finally, and I again say this recognizing laws aren't the easiest to read, but if you have an idea of what law you may have been convicted under, you can search here to identify the number to see if it is in fact an ineligible offense. So with that being said, again, I'm going to encourage you all to visit our website to sign up for our mailing list to get more information. And thank you for joining us today. And I look forward to tomorrow's session.
Thank you all. Please tell a friend, tell someone who may be in need of this information, and we look forward to seeing